Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to head back down to Florida again. We got to talk about that very disturbing shooting that took place last month. As we know, an Okaloosa County Sheriff's Deputy Eddie Duran, fatally shot 23-year-old United States Air Force Airman Roger Fortson as he opened the front door of his apartment. Now, the first video we did about this one here, got quite a bit of fallout, good and bad, had a lot of you talking. We're going to circle back on that. But it appears that the Sheriff's Department now has released its findings on one of their own, and it does not bode well for the deputy that was involved. So today we're going to go through some of those findings. We're going to talk about some other things as well. So let's spend a few minutes, let's geek out today, and let's talk about Sheriff's deputy who killed Airman fired after findings released. Okay, we're going to circle back to Florida now. Dateline May 3rd of this year. As we know, an Okaloosa County Sheriff's Deputy was placed on administrative leave after he gunned down a 23-year-old United States Force Airman Roger Fortson as he opened his door, having the audacity to be armed with a firearm. Now, listen. We're not going to show the video all over again. We already did this video right here. We fought like hell with Google to get it out, and then they got all pissed off because we apparently showed some violence. So we're not going to show what happened again. You guys are all aware of it, and we really don't want to get Google pissed off at us again. By the way, speaking of pissed off, you know who else was pissed off about that video? Apparently, attorney Andrew Branca of the Law of Self-Defense. Apparently, we have been engaged in shameful misinformation. Okay, now, as I explained at that time, I was basing my opinion on what I knew based upon the video, and I made it very clear that what I had seen so far led me to believe that it was a bad shoot. And where I had focused most of my attention on the video was in all the things the officer had done to place himself in that position to begin with over something that was, in all likelihood, not an emergency whatsoever. Well, Dateline, May 30th of this year, the Okaloosa County Sheriff's Department has released its findings as it relates to this issue, all 29 pages of these findings, after conducting interviews with multiple individuals, including the deputy himself. We're going to go through a couple of very specific findings, but I got to tell you, this does not bode well for Deputy Duran. The department here has found that he did not have lawful authority to use lethal force, and they have terminated his position with the Sheriff's Department. Now, I want to make it clear that that is not the aha, I told you so moment, okay? What this is that on a professional employment basis, the County Sheriff's Department has determined he acted outside the scope of his authority. He acted outside the scope of his training and regulations, and for that reason, he has been terminated. This does not mean that he is going to get charged with a crime, although he could, but this will have no bearing on that. There is a separate investigation ongoing right now as to whether or not he should be charged with a crime. However, for those people out there who thought that the deputy was totally okay to be doing what he was doing, well, this certainly doesn't strengthen that argument now, does it? Now, I do want to go through a couple of the very specific findings, particularly from the interview of Deputy Duran himself. I don't want to be engaged in shameful misinformation. Now, one of the questions that was asked of Deputy is, you know, when you pounded on the door the first time, you never announced that you were with law enforcement. Why was that? Well, this is what the deputy had to say. I asked Deputy Duran why he did not announce himself when he knocked on the door at the first time. He said, quote, initially, what I'll do is I'll knock on the door, kind of listen for a response. Generally, if it's who's there, who is it, or what do you want, you know, get away from the door. Anyway, whatever the response is. So I'll knock, and I guess, you know, you could say a normal, typical knock to see what the response is going to be. Well, first of all, I would not call that a normal knock if you go back and watch the video. But he essentially is saying that the first knock he makes on the door, he intentionally does not tell the individuals inside that he is in law enforcement. That is an important factual finding. Then one of the other important factual findings is Deputy Duran is adamant that in the half second that he got to look at Mr. Fortson, he was convinced that Mr. Fortson was about to commit violence upon him, and he had no choice but to act. Now, you may recall that there were shots fired, and then he ordered Mr. Fortson to drop the firearm. Well, the investigator asked Deputy Duran about that as well, and this was his response. I asked Deputy Duran if he considered telling Mr. Fortson to drop the gun or issue other commands. He answered, based on everything that I had taken into account, I felt 100% that action was going to be my best course as opposed to reaction. And of course, that action was to gun Mr. Fortson down. Now, we're not talking about self-defense or defense of others as we talk about normal citizens. We are talking about law enforcement, and in some jurisdictions, law enforcement may have greater leeway to use force, and in other jurisdictions, they may have greater levels of responsibility when they are using force. But the applicable case law, which governs what is reasonable force that law enforcement can use, is the United States Supreme Court of Graham v. Connor. That case specifically states, objective reasonableness is defined as evaluating each situation in light of the known circumstances, including but not limited to the seriousness of the crime, the level of threat or resistance presented by the subject, and the danger to themselves and the community when determining the necessity for force and the appropriate level of force. The reasonableness of a particular use of force will be judged from the perspective of a reasonable law enforcement officer at the scene and allow for the facts that deputies are often forced to make split-second decisions about the amount of force necessary in a particular situation. Okay, and even though the state of Florida may give broad discretion for law enforcement officers in general to use force, let us also remember that there are internal policies which govern the actions here of the officer. Now, again, this could lead to termination of the position. I am not saying that it automatically equates to criminal conduct. But as the report pointed out, although Florida statutes give a wide range in the use of force to law enforcement, Okaloosa County Sheriff's deputies are authorized to use only that amount of force that is objectively reasonable to perform their duties. And listen, I do not for 1 second want to suggest that this is not one of the most difficult jobs on the planet. And yes, decisions have to be made in split seconds. And I think everybody that's ever watched this channel knows that we are incredibly pro-law enforcement. That being said, law enforcement officers are human beings as well, which means they are capable of making mistakes. And sometimes the mistakes they make can be quite large. They can be very costly mistakes. They have already been incredibly costly to the Fortson family. And my concern is that this may turn out to be very costly to Deputy Duran's family as well. The commission that was tasked with doing this investigation spent considerable time doing what we did on the first video, which is you have to focus a lot about what Deputy Duran did to even get himself in that position. You have to focus on the reliability of the information. You have to focus on the second, third, or fourth-hand nature of the information and some of the lack of specifics. You have to focus on whether or not Deputy Duran even had any right to go up and pound on that door to begin with. All of that is part of the decision-making matrix here as well. And for that reason, the findings specifically state the objective facts presented to Deputy Duran were the following. 1, he was dispatched to an in-progress physical disturbance in an apartment. 2, he received second-hand information from the leasing agent about the current incident, and she relayed an incident from weeks prior that had happened in the area of the apartment he was responding to. 3, he listened for sounds of a disturbance at the apartment door and did not hear any. 4, he knocked without announcing his presence and listened for a response. 4 times Deputy Duran qualified what he believed Mr. Fortson said by saying something to the effect of. When describing what he heard, Deputy Duran said something to the effect of, "Oh, it's the effing police." 5, he knocked 2 more times and announced his presence both of those times. 6, when the door opened, Deputy Duran said Mr. Fortson was moving towards him. Deputy Duran said step back, and Deputy Duran said he, Fortson, took another slight step forward. 7, he described seeing aggression and anger in Mr. Fortson's eyes. Deputy Duran further described Mr. Fortson as having a disconnected, non-inquisitive stare. 8. Deputy Duran saw Mr. Fortson had a firearm in his hand with his elbow slightly canted. He described the firearm as not pointing at him. The firearm was pointed at the ground sufficiently enough for Deputy Duran to have clearly seen the rear face of the rear sight. Based upon all of these factual findings, this is what the Okaloosa County Sheriff's Department determines. Okaloosa County Sheriff's Office General Order 04.01, Response to Resistance, Section F2D states, deadly force resistance is a subject's hostile, attacking movements with or without a weapon that creates a reasonable perception by the officer that the subject intends to cause and has the capability of causing death or great bodily harm to the officer or others. The objective facts, as discovered in this administrative investigation, do not show Mr. Fortson made hostile, attacking movements, and therefore the objective facts do not support the use of deadly force as an appropriate response to Mr. Fortson's actions. Deputy Eddie Duran's use of deadly force was not objectionably reasonable. And then they go on to state, the facts and evidence showed Deputy Eddie Duran's use of deadly force against Mr. Roger Fortson was not objectively reasonable. OCSO General Order 11.03, Section E, Paragraph 35, excessive use of control to resistance is sustained. Signed, Captain Robert A. Wagner, who is in charge of professional internal investigations. Now, as I said, this is a huge blow to Deputy Duran on a professional level. This does not necessarily mean that the prosecuting attorney is going to come to the same conclusion and charge him with manslaughter. However, if you are Deputy Duran's attorneys, this would have you deeply concerned that at least one other set of eyes has already looked at this and said, hey, this is without lawful authority, quite similar to what we thought the very first time we saw it. Listen, we're going to go ahead and link up everything down below so that you guys can see what the Sheriff's Department said. Hey, by the way, if you got ideas for videos that we should be doing around here, go ahead and click on that link right there. Some of the best ideas we ever had weren't really our ideas. If you need to get a hold of Washington Gun Law, all of our contact information is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.